Morning, everybody. Good morning, everybody. Welcome to meeting number 3 of the Senate Standing Committee on Judiciary. We were waiting. I know VMAP was running a little long next door, so we were waiting on some folks to come over, both members and sponsors. Chelsea, if you don't mind, please call the roll.
Senator Berg. Present. Senator Carroll.
Here.
Senator Deneen. Here. Senator Neal. Senator Schickel. President Stivers. Here. Senator Storm.
Here.
Senator Turner.
Here.
Senator Wheeler.
Here.
Chairman Westerfield.
Here. Seeing that we have a quorum, we're authorized to do business. So let's jump right in here. I know, Senator, you ready, Senator Girdler? I got you fresh as you walked in the door. You can come on up if you'd like. Excuse me while we mute Senator Schickles. All right, Senate Bill 199, an act relating to crimes and punishments. Senator, you have the floor.
Thank you, Senator Chairman. Chairman Westerfield. This bill was brought on. I was asked to carry it by a constituent of mine, and really hadn't put a lot of thought in it. I just wanted to protect the ladies or anybody that was being stalked or having devices put on their car to find out where they're going, and whether it be a EPO or yeah.
Got a motion from Senator Schickel and a second from Senator Wheeler. Anybody have any questions? Bill's pretty self-explanatory.
We do have a sub, don't we?
Do we have a sub on this one? Let us double check, because I didn't think we did have a sub on yours.
All right.
Hold on. The last 3 do.
All right.
Excuse me. Yeah, the last 3. I don't think we've got a sub.
No sub. Well, Roberta tells me we have no sub. Me and Senator Berg's been in a meeting that kind of rattled me.
I understand. Mm-hmm. Okay, Roberta, is there? I didn't think so. Thank you for
There's no
double
sub.
check. Yeah, so we're good to go. We've got a motion and a second.
Chairman Westerfield.
Does anybody have any questions? Senator, ma'am? Okay. I appreciate it. This is something that's been popping up. Apple's not the first one to do it, but they've got these air tags, and I've got them on my keys, and I bring an extra when I travel and throw one in my check luggage if I have to do that, just to keep track of it. Amanda's got some on her keys. But there are other device manufacturers. Tile is the other leading manufacturer and brand of these devices, but they are being used for this purpose very inappropriately. So I appreciate you bringing the bill.
Thank you. Well, with your help, it was, and I appreciate your help on it and let me do the bill.
We got a motion and a second. Madam Secretary, please call the roll.
Senator Berg.
Aye, and thank you. I think this is a good bill.
Thank you.
Senator Carroll.
Aye.
Senator Deneen. Senator.
I explain my vote.
Yes.
Thank you for bringing the bill. I think this really moves us in the right direction as Kentucky continues to lead the nation in domestic violence and sexual violence. I think your bill really adds to the efforts to move us away from that leading position and give these victims of those crimes a better sense of security. So I appreciate you bringing the bill.
Thank you.
Senator Neal. Senator Schickel. President Stivers. Senator Storm.
Aye.
Senator Turner. Senator Wheeler. Chairman Westerfield.
Bill passes with favorable expression, unanimous. I'll entertain a motion for consent. Second. All those in favor, please vote by saying aye. Aye. Those opposed? Easy peasy.
All right. Thank you. That's the
Thank you,
easiest
Senator.
thing I've done today. Thank you.
All right. Mr. President, would you like to go next?
If you wish, Mr. Chair.
Maybe not. I'm just kidding. No, I'm just kidding. It's my only moment of power. I gotta use it for something. Mr. President, you may proceed on Senate Bill 203, an act relating to the confidentiality of mental health records.
Thank you, Mr. Chairman and members of the committee, and to the individuals watching. This was just a moment of levity in a time that the legislative session probably needs a few moments of levity. But thank you. I want to go through a bill and situation, and as a practicing lawyer who doesn't practice as much, this is actually one area I do practice in, and I want to thank you, Mr. Chairman, because you and I had a meeting on this. We both have practices in this area. For individuals who are not aware, medical records are confidential and protected by federal legislation. Most people understand it. It's called HIPAA. So when you get into just what I think most people think of medical records, that's is your arm broken, your leg, you've had some medical condition, it goes well beyond that, and it goes into your mental and psychological records. Those are even more protected under HIPAA. So what we have seen, and it came to our attention, Mr. Chair, is that there's probably not tight enough guidelines in our state code, and this change, and I will give you a situation, and it's not been exclusive just to this situation, were appropriately medical records related to mental health and psychological records were obtained, and then the hearings went through, but there were very limited protocols placed upon the individuals who received the records. This would put basically the protocols that are described within HIPAA in state statute to say, and this is something, again, you and I, Mr. Chairman, do when our mental health provider clients get subpoenaed to provide records, that we get an order that says, look, you will only use these for limited purposes, you will only have limited dissemination, and upon the conclusion of the matter, they are not to be disseminated, they are either to be returned or destroyed. This brings Kentucky statutes in conformity with federal statutes in HIPAA, so that you don't all of a sudden get the records and one party or another, or the records are not sealed, somebody goes to the records and you see a Facebook post talking about your mental health records that may be appropriate for a hearing but are not appropriate for public dissemination. That's this bill.
We got a motion from Senator Turner and a second from Senator Neal. Did you have a question also? Oh, okay. Thank you. Any questions of the sponsor? Seeing none, Madam Secretary, please call the roll.
Senator Byrd,
Aye, and thank you, sir.
Senator Carroll,
Aye.
Senator Deneen,
Aye.
Senator Neal, Senator Schickel, President Stivers,
Aye.
Senator Storm,
Aye.
Senator Turner, Senator Wheeler, Chairman Westerfield.
Aye. Bill passes with favorable expression unanimously. Once again, thank you, Mr. President.
Thank you, Mr. Chairman, members of the committee.
Senate Bill 225, an act relating to persistent felony offenders. Senator Storm, come on down. You have the floor when you get there. Thank you. And thank you, Matt, for the reminder. The last three bills, members, do have subs. They were sent yesterday. I announced that on the floor. They're in your... Thank you. Got a motion from Senator Schickel and a second from Senator Neal on the substitute. All those in favor of adopting the substitute, please vote by saying aye. Aye. Those opposed? The sub is before us. Senator, you have the floor.
Thank you. Brandon Storm, Senator of the 21st District. My guest will introduce himself.
My name is Scott West. I'm the Deputy Public Advocate for the Kentucky Department of Public Advocacy.
We're here today to talk about Senate Bill 225, and I want the committee to understand what the bill is not. The bill is not soft on crime. Any continuing criminal behavior, crimes that are committed while on probation, parole, or during incarceration, may be punished in accordance with the original intent of the statute. It's jury empowerment is what this bill is about. It continues to provide harsher sentences for the most serious offenders, those who commit any acts of violence against a person or a sex crime as defined in KRS 17500. Again, Section 1, Paragraph 1A, the jury may fix an enhanced sentence of imprisonment as authorized by Sections 5 and 6 of the statute. This denies alternative sentencing for Class D offenses involving a violent act against a person when sentenced to first or second degree PFO. It preserves mandatory sentencing for Class D offenses involving violent acts against a person when sentenced to first degree PFO. It empowers juries, most importantly, to determine an individual's status as a persistent felony offender. It restores judicial discretion by expanding alternative sentencing to nonviolent Class C offenses, and it closes the eligibility window for individuals with completed sentences. Lastly, removes mandatory sentences from nonviolent Class C offenses. And Mr. West is here to answer any technical questions.
Members, are there any questions? Senator Schickel.
Thank you, Mr. Chairman, and I want to thank the bill sponsor. He's a good man, and he's talked to me about this a lot, and I sure appreciate it, as well as the Public Defender's Office. I actually had a bill about jury enhancement several years ago that didn't get heard, but this does a couple other things. I want to read you a text from one of my judges, and then if you could just respond to it. It says, this takes away punishment for persistent offenders. The law already punishes people on probation and parole if they get a new crime, meaning time is consecutive and not eligible for probation in most instances. The PFO is designed to get, it says to get the guys, excuse my slang, who keep offending. Just respond to that if you could. I apologize for the informal language. And I will have a follow-up if you'll allow, Mr. Chairman.
Yes.
Actually, what the PFO law was designed to do was to take those people who are not rehabilitatable, the incorrigible, the recalcitrant or intransigent, the ones that are just never going to change, and incapacitate them. We're no longer going to rehabilitate them. And as we started out, you had to have at least 2 services at prison, and you had to after that, go back and reoffend. But the problem is, while other states were saying this is triggered by a violent offense or one of the things that we're afraid, one of the the offenses we're afraid of, Kentucky made it applicable to all felonies. And the problem with that is, as my law professor, Bob Lawson, who I admire greatly, put in his article, is the problem with a repeat offender law that extends coverage to all defendants with a felony record is that you catch a few of the people you're trying to get, but you throw too big of a blanket, and you end up getting a lot of people who aren't actually the public safety threat that we thought they would be. And so that's what it was designed to do. What happened is the General Assembly, I'd say 3 decades ago, started getting the idea that instead of doing a blanket thing, we need to really target the offenses that we want to incarcerate people on. So you start seeing second or subsequent offense enhancements. You see violent crimes listed, and the list continues to grow. You see 50% parole eligibility for violent crimes go to 85%. You see no probation, no sharp probation, no conditional discharge for those people. You see that they can't even be paroled until they've served 85% of their sentence. You see all of these things that are targeted towards the very worst crimes and the most incorrigible people. So basically, the PFO is now been supplanted by things which do the job much better than the PFO, and the only people that are left being caught up in PFO are people who weren't incorrigible. We could have done something to rehabilitate them, but now we're putting them in prison so long, we're turning them into the incorrigible and taking away the hope, taking away the promise of trying to do better. So that's kind of what this bill does, and in my opinion, some of the provisions of the current PFO law as it is serves only to give the upper hand to the state in negotiations, even though to take the biggest time available on the underlying charge with the promise of dismissal of the PFO, and it's become a negotiating bargaining tool, not what it was designed to do, which was actually put away repeat offenders who are never going to get it, and they probably never were.
Your follow up?
Thank you. He actually answered my second question, so there's no need to follow up. I will comment when I explain my vote. Thank you, Mr. Chairman.
Yes, sir. Any other questions? President Sowers.
Actually, I'm going to look and direct this at maybe both the sponsor and both our committee member. Senator Schickel said that he had a bill, and I thought your bill wasn't that a jury, and I'm just trying to get a distinction, that your jury did not have to have a mandated cause of finding a PFO or not. It was just a consideration. You know, what was the difference between sorry, Mr. Chairman, this is what I think the committee process should be.
I agree with you.
Differential between this bill and what Senator Schickel had a few years
ago. Well, and I appreciate that question because this is an interesting discussion. And actually, the counselor at the table and myself worked on this bill together. So if my memory is flawed at all, counselor, please correct me. But because it's been several years ago. But the way I remember the bill is that it actually for a PFO to stand, the jury had to, and for lack of a better word, had to endorse it, had to recommend it. And the idea was to try to get more jury trials, and it wasn't simply up to the prosecutor. But the difference between that bill and this bill, the way I understand it, is my bill didn't take any offenses off the table, and this bill does.
That's a good summation. The jury still finds whether the person is a PFO eligible person, and once they make that finding, they get to decide whether to go with the penalty of the underlying felony or the enhanced penalty as a PFO. That is where they get to make their election. But what is still on the table is if you have that PFO finding, so many, the sexual offenses, the violent offenses, those remain subject to something outside the jury's discretion. They still can't be probated. They still can't be paroled if they're violent or sex crime. Some of these other things are add-ons. They are in addition to the bill that we presented to you, Senator Schickel, but they're in response to things that the General Assembly has already done in the past, which is really tighten up on sexual offenses and violent offenses, and you've taken scalpels to some of the worst crimes and the most violent crimes, such that the general catch-all now is only getting the things in the net that you didn't want to catch in the first place. And so that is a substantive change from the bill that you had, Senator.
Motion on the bill.
Thank you. Got a motion from Senator Wheeler and a second on the bill from Senator Neal. Senator Sowers, President Sowers. Okay. We have a motion and a second on the bill as amended by the substitute. We did adopt the sub at the beginning. That's right. Any further questions? Seeing none, Madam Secretary.
Senator Byrd,
Yes, and thank you.
Senator Carroll,
No.
Senator Deneen, Senator Neal, Senator Schickel,
No, and I'd like to explain my vote.
Yes, sir.
Again, I really do appreciate this discussion. It's been open and frank, but there's a couple things I want to say. First of all, I cast this vote from a larger perspective of what's going on and what has been going on in the Commonwealth of Kentucky ever since I've been in the General Assembly. We are experiencing, the public is very concerned about crime, and they don't understand all this. And we're in the midst of a horrible crime, especially in my part of the state, and I think in others, as it relates to juvenile crime. We're hopeful there's a bill coming over from the House. We've been tried for year after year to get it over. We're hopeful that it will get over this year and we'll get it passed, and that will be maybe one first small step in addressing this problem. The other thing I want to say is that I guess really what I said before is I appreciate the jury, that part of the bill, because I think that is the answer. One of the answers to our criminal justice is we need more jury trials, and we tend to resist that because jury trials equal work for everyone, and human nature is we don't want to work. And so I get that part of it, and I really do appreciate that. Now I can't remember if I voted yet or not. Did I, Mr. Chairman?
Pretty sure you did.
Okay, thank you.
President Stivers, Senator Storm,
Aye.
Senator Turner,
Can I explain my vote?
You may.
Mr. Chairman? I appreciate this bill as a practicing lawyer that 40-some years in this. To change what my good friend was just talking about, we have this simple thing that I see all the time from giving a wrong ID, a name, that can get you enhanced if you've already got problems. Throwing a bag of marijuana down, it becomes a felony. It's just we got some things we're going to have to change there to keep this, and this is a good bill. I hope we work some more on it and eliminate little things if this bill comes from the House that I'll hear about. And my aye vote stands.
Senator Wheeler,
Mr. Chairman, explain my aye vote.
Yes, sir.
You know, although I share my colleague Senator Schickel's concerns about the rampant crime waves that are impacting large parts of the United States and the Commonwealth, I do have great faith in our juries and citizens of the community to make these types of decisions, and I don't see that it really takes anything away from the system. It merely gives more empowerment to the members of the community sitting on that jury. So for that reason.
Chairman Westerfeld,
I vote aye, and to explain my vote, I was once reluctant to wade into the PFO waters, but I think this bill is really carefully done and responsibly done, giving the jury the power to make a decision and use discretion, giving the court additional discretion, and narrowly doing it in a way that helps do exactly, Scott, what you were talking about. Make sure that this is targeted at the very people that PFO is supposed to be getting and keeping behind bars and keeping them there longer, not the people we've got a chance to turn their lives around for. So thank you.
Thank you.
Bill passes with favorable expression 8-2. I appreciate it. Thank you very much. I'm going to go in order of seniority, Senator Yates, and yield to your colleague. Come on up. Senator Denise Harper Angel on Senate Bill 282, an act relating to victims of crime. I don't want to steal your show, so I'm not going to talk about what the bill is. And there is a committee substitute, and I'll thank you. And I'll make the second from Senator Wheeler first motion, and then second from the chair. All those in favor of adopting the substitute, please vote by saying aye. Aye. Those opposed? The sub is before us. I'm embarrassed to say I had no idea this loophole existed. I've talked with countless victims during my time in the prosecutor's office, and through work with Marcy's Law and other policies. I had no idea. So I'm glad you brought the bill. Senator, you have the floor.
Thank you, Mr. Chairman. Good morning, members of the committee and Mr. Chairman. I'm Denise Harper Angel, Senator from Jefferson 35. I have with me today John Hardesty, and I'll ask him to introduce himself for the record.
Thank you, Senators. John Hardesty, Executive Director, Office of...
John, make sure your mic's on.
Thank you.
Thank you.
John Hardesty, Executive Director, Office of Claims and Appeals.
Thank you, Mr. Chairman. We had a really good working group that worked together during last year's interim. They found this loophole. I also filed another bill, which is much more comprehensive, as an educational tool for this session, this short session. I'm hoping we can look deeply into that during this next interim. That's Senate Bill 283. But 282 increases the award caps for awards to crime victims of the Crime Victims Compensation Fund. Senate Bill 282 would increase the lost wages of financial support caps from $150 a week to $300 a week, which has not been increased since 1976. The funeral and burial expense cap from $5,000 to $7,500, which also has not been increased since 1988, and the overall cap award, including medical and mental health counseling expenses, from $25,000 to $30,000, which has not been increased since 1986. It also clarifies that hit-and-run victims do not have to prove that the driver of the vehicle was under the influence or that the hit was intentional to receive benefits from the fund. There is no new money needed to increase the caps. We just need to give the board the approval to use the funds they already have. We do that in the committee sub. Finally, we added an emergency clause to allow victims of the claims for compensation under the new caps in the last quarter of our current fiscal year instead of waiting until next year. I'll be happy to answer any questions.
Motion on the bill.
I've got a motion from Senator Wheeler and a second from Senator Schickel, whose voice I heard over a couple. Again, I having dealt with victims filing claims under what was then called the Victims' Comp Board, I knew that a conviction was necessary in order to do that, but if you don't have like a criminal case, there's no defendant to go after, they're stuck. So that never occurred to me. So I really am grateful for the bill. We do have one question from Senator Stivers.
Senator, I have a question on this about the hit and run. As I understand hit and run, the hitting may not be criminal. The leaving is. That's the criminal portion of this. So even though the action may have been negligent in hitting Senator Wheeler, the leaving. No, that was intentional. Well, I understand that too. We're getting into more levity at the time when we need that. But the hitting of Senator Wheeler may have been negligent. The leaving is the run, which is criminal. So the action for which he seeks compensation, which is the actual hitting, is now going to be compensable even though that part is not a crime. Is that fair?
I'm going to defer that to John Hardesty, please.
Senator, I believe that when those incidents happen, the circumstances give rise to a crime. This would make the victim, this would make the crime compensable. This individual qualify as a victim because when the individual runs, they have no other recourse. They don't know who did it. Oftentimes insurance does not cover it, and so it does give rise to a crime. If they ever found that individual, they would charge them for the hit and run crime, which would make it a crime compensable under this.
I also think there's that failure to render aid. They might sustain injuries that they wouldn't have had it gone treated, had they gotten help, had the person stayed and provided aid instead of running.
And if I could, Mr. Chair.
Yes.
I know the assumption is generally you run because you think you've committed some criminal act, like you're under the influence, correct, or you were speeding, or you were looking at your cell phone or something of that nature. But that's an assumption that generally is only assumed and not necessarily that you can punish somebody, because if, there could be circumstances, and there have been, in which the individual, thought they hit a dog or thought, and I know people are going to but there have been misinterpretations of an accident that now you're going to make something that may not be criminal compensable.
Senator, I will just give examples of situations that we have arise in front of the board. Oftentimes pedestrians are hit by motorists, and under the current law, the only situation where a victim can be compensated by the board for a crime involving a motor vehicle is when the driver is under the influence, or there's evidence that it's done intentionally. And oftentimes, going along with what you said, I think the belief is that in lots of those cases where the driver runs, there may be something else going on there, perhaps that would fall within one of those current situations within the law that would allow the victim to recover. And this is a loophole that oftentimes arises in front of the board. We'll have folks call or submit claims, and under the current law, the board has no choice but to deny those claims when, in fact, those victims have no other recourse and are in need of the board's assistance.
Thank you, Mr. Chair.
Senator Schickel.
How does, if I, let's say I'm involved in a hit and run and I do have liability insurance coverage, whatever the state minimum is, how does that work as far as the compensation board and the insurance? Is there any coordination there, or what is the insurance company's obligation?
Senator, we have, there's a statute that sets a number of different offsets, collateral offsets for crime victims' compensation. So if insurance is available and will pay for the injuries for which the victim seeks compensation, we would not pay that from the Crime Victims Compensation Fund. And I will say our investigators are very thorough in looking for collateral sources to ensure that money is not paid out unnecessarily.
Thank you, Mr. Chairman.
What is the, if I can ask, what is the, if assuming this passes, we have someone files a claim, what investigation or review of that claim is undertaken by the board?
We do a thorough investigation. So once we receive the claim form, which the claimant fills out and includes lots of information about their injuries, the crime that occurred, what law enforcement agency they reported it to, our investigators will then, well, it'll be assigned to one of our investigators, and then they will gather all law enforcement information. If there's a police report, they will obtain that. They will interview detectives.
Is a police report required?
Not in all circumstances, but in most, we need a police report to prove that there's criminally injurious conduct. Oftentimes, we'll talk to detectives too if we need more information about the crime or about the alleged crime that they've submitted the application for.
I obviously support the bill, or I wouldn't have given it a hearing, and I'm about to vote yes on it. But I think it would behoove the Victims' Comp Board to carefully consider its investigation steps, what evidence it requires, to make sure people don't file frivolous claims or fraudulent claims under this very fact pattern, which is probably why the carve-out was there to begin with. Because, I mean, simply put, that's money going to someone that's not going to a victim that actually needs the compensation. So I would encourage you all to be very careful. You can't conduct a full-blown trial yourselves, and I don't know what sort of staff the Victims' Comp Board has, but you obviously need to be very vigilant about that.
We will certainly do that, Senator. Thank you.
Any other questions? Seeing none, we've got, do we have a motion on the bill as
Made a
amended?
motion.
Thank you, from Senator Schickel, and a second from who? Wheeler. We'll take it. Madam Secretary, please call the roll.
Senator Berg,
Aye, and thank you.
Senator Carroll,
Aye.
Senator Deneen,
Aye.
Senator Neal, Senator Schickel, President Stivers.
Explain my vote.
Yes, sir.
I think this is a really good bill, and the increase in potential compensations is long overdue. I think the chair was more articulate in explaining what I was laying out in scenarios that we want to make sure is truly a victim of a crime that gets compensated, and people don't come in and start alleging something that was not necessarily criminal in nature.
Was that a yes? The Secretary was checking. She wanted to make sure.
Senator Storm,
Aye.
Senator Turner, Senator Wheeler,
Aye.
Chairman Westerfield.
Aye. Bill passes with favorable expression, I believe unanimously. Thank you, Senator. Do you care?
I always love consent, Mr. Chairman.
We've got a motion from Senator Schickel and a second from Senator Neal. I think beat you to it this time, Senator Wheeler, to put this on consent. All those in favor of the consent calendar for this bill, please vote by saying aye. Aye. Those opposed? There you go. Senator, thank you.
Mr. Chairman, there is a title amendment.
There is indeed. John, thank you as well. Members.
Thank you, Mr. Chairman.
We do have a title amendment. I'm going to explain this briefly, and you can correct me if I'm wrong, Senator, but we needed to do this because of some budget language that Becky tried to explain to me yesterday that I don't understand. But I do know that it's necessary so that this can work, and it doesn't involve opening the budget. There's no appropriation. We're not actually spending new money because we're just raising those caps. So I'm going to make a motion on the title amendment to adopt that. Is there a second? From Senator Wheeler. All those in favor of adopting the title amendment, please vote by saying aye. Aye. Those opposed? Thank you.
Thank you, Mr. Chairman, members of the committee.
Yes, ma'am.
Thank you, Senators.
Thank you, John.
Thank you, John, very much.
Actually, now, Senator Yates, you can come on up while I'm talking about it, and Roberta and Matt make note of this. It might not be a bad idea to have the Victims' Comp Board and have Mr. Hardesty on during the interim sometime to talk about their process. And did you hear that? I just put you on the spot again. Sometime this summer, I'd like to have you back and just walk us through that entire process. I think that'd be Thank you. Senate Bill 268, an act relating to child support after driving under the influence. Glad to have this bill, and I'm glad we both stole from Tennessee.
That's right.
Senator Yates, you have the floor, sir.
Thank you, Chair Westerfield, members of the committee. Thank you for having me here. I'm David Yates, Senate District 37, Jefferson, and present Senate Bill 268. And as the chair just said, I'm not about reinventing the wheel. I like to perfect it, but not reinvent it. This one is personal to me. I think it's before that, we have a proposed Senate substitute.
Thank you. We do have a committee sub. We've got a motion from Senator Wheeler, I think, and Senator Storm made the second. All those in favor of adopting the substitute, please vote by saying aye. Aye. Those opposed? The sub is before us, Senator. Thank you.
Okay, thank you. Without saying this is going to allow our courts to order restitution in the form of child support in DUI cases if the defendant is a convicted individual that causes the death of a parent or guardian of a minor child, or has resulted in the parent or guardian of the minor child being disabled, total and permanently disabled. I've named this act Melanie's Law, if it would please the committee. My cousin Melanie Hull is she's 2 weeks younger than I am. She's currently hooked up on machines, life-sustaining, fighting for her life. On 7/2/22, her and her little boy, Nolan, were in a motor vehicle, and a drug driver ran a red light. Amber Washington ran a red light and hit them on the way she was dropping off to preschool. We pray for a miracle every day for Melanie, but we know there's no way that she will ever be able to provide for this child. And in my practice, like many attorneys on here, we see this situation over and over again. And to me, a lot of times people have minimum limits. You'll have the $25,000 come in. They'll do a little bit of time in prison, and they come out and they move on with their life. But for Nolan, he's going to struggle. And so what I believe is this is about fairness for the child. This is about accountability for the offender. It's a deterrence effect, because this is something people will talk about. It encourages justice for victims. We keep talking about increasing penalties, increasing crimes. This isn't an increase of a crime. This is a restitution. This is trying to make right your wrong. So while this individual, when she gets out of prison, writing that check may not be the end of everything, she will write that check, and she'll think about that child that's surviving, like so many of our constituents here in Kentucky. And I think this is a very positive. We don't know how much this will encompass, but I think it does give the sentencing court that ability. I think it's a positive, and I would encourage a yes vote.
Motion on the bill.
Got a motion from Senator Wheeler and a second from Senator Neal. Any questions, members? Yes, Senator Schickel.
Thank you, Mr. Chairman. I always am cautious when we get bills that are very emotionally and personally charged. And I don't know that I understand the bill completely, but I just wanted to ask you one question, and that is, you said in your testimony this gives the court the opportunity, so this is an option.
May I respond, Mr. Chair?
Yeah, please, of course.
Thank you, Senator, for that. The word shall be shall, so it'll be a requirement of restitution. What you'll look at it in the print of it, in the event that the child would have been made whole, let's say that there was property insurance there was something that, and there is a civil suit, it'll be offset to the point that they have been made whole. If they've had full satisfaction of the damages. In the event that the defendant's insurance, if there was defense insurance that could pay for it, but they shall order restitution for the lost wages or permanent impairment or power to work for that. What they're doing is if you've taken the parent away that would have provided support for the child, the court shall order restitution in the point of child support. And I know it's emotional here, and I'll tell you it's been emotional for the years I've been practicing law. When I have a case come in, I've had a lot of injury cases with drunk drivers, drug drivers, and a lot of surviving children. I think this is a positive. We're starting to see this move. While the penalty's in place, that civil judgment sometimes is bankrupted. or they don't have anything. It's bankrupted. But this will be a restitution. Restitution survives those things. It'll be in the criminal sentencing, it gets ordered. So while they may not have a whole lot, there will be a check written as form of that restitution. To me, I think that's so important, even if it's de minimis. Does that answer your question, Senator?
It does. Thank you.
Thank you.
Any other, Madam Secretary? I believe we've got the sub already adopted, so please call the roll.
Senator Byrd,
Aye.
Senator Carroll,